Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Williamson. Good morning. My name is John Bailey. I'm the Chief Justice here at the Eastland Court of Appeals. I'm joined by my fellow justices, Stacey Trotter, who hails from Odessa, and Justice Bruce Williams, who came here from Midland. We're ready to go. I wanted to ask one question of clarification to the appellees. Based on the sheet that I've been given, you've divided your time up 10 and 10. Is that correct?
Yes, Your Honor.
All right. Now, I will tell you, this is my experience watching several oral arguments. The first one always goes over. So, and usually what happens is that the one that's second, we're in the actual courtroom where people get to see each other. Starts, throwing a pen or making a noise like, hey, you're running over. So you're in different places. I don't know how that's going to play out. If I happen to see it at 10, and you're still going, I'll let you know. But I do that tongue in cheek. We're pretty flexible and friendly is how that goes. But we won't keep the time. It'll just be the one time and you'll keep up with it. So with that being said, the court will call at this time cause number 11-2028 CV, Foote and Cypert versus Texcel and Decker. Mr. Lovell, are you ready to proceed?
Yes, Your Honor.
You may.
Judge, the Eastland Court of Appeals has 3 times held that an owner of livestock can sue an oil and gas lessee for negligence in killing or injuring that livestock. And yet, the trial court in this case denied my clients the opportunity to even submit a question on that. The 3 cases are Weaver versus Reed, 303 Southwest 2nd, 808. Curry versus Ingram, 397, 484. And Texaco Inc. versus Spires, 435 Southwest 2nd, 550. The Weaver versus Reed case is important, particularly important in this case, because it limits the application of Warren Petroleum versus Martin, which is the primary case that the defendants are asserting to claim their lack of duty. And what this court held or determined in Weaver versus Reed was, number one, in Weaver versus Reed, there was no evidence of negligence. There was not a negligence claim. And that court recognized that a tort duty could arise that would change the outcome. And that's what's happened here. The other thing that Weaver versus Reed did is it made the distinction of when an operator is acting within his rights to reasonably use the surface in order to produce oil and gas, and when his activities don't. And that's an important distinction here. Another point to make on negligent undertaking, of course, one of the elements of proof is that the action was undertaken in order to benefit the third party, in this case, my clients. Well, despite the statements in defendants' briefs, there is testimony of that. Tommy Decker at 4 Reporters Record 35 said he didn't think the fence was necessary to protect any of their equipment because it was all metal. Cattle, he didn't think the cattle could hurt it. So he understood he was there to protect or keep the cattle out, not to protect his equipment. David Stapp, in response to his own attorney's questions at 4 Reporters Record 356 and 57, said with his decades of experience as an operator that fences are primarily to protect the livestock due to moving parts and other potential dangers to the livestock. Mackie Yates, the lessee of the farm, through the testimony of Keith Cypert, made clear that he is the person in possession of the premises, with the right to exclude, that it was the oil company that had the duty to keep the fence, and the cattlemen should leave the oil company's stuff alone. And both Decker and Stapp and Cypert all agreed, it's a general understanding in the oil field that cowboys and farmers are supposed to leave that oil equipment alone. It's not their stuff. They don't understand it. They're not to mess with it. So there clearly is evidence that there was a duty undertaken and it was relied on. Another important point on this negligent undertaking, this claim is not dependent upon the legal status of Tim Foote or his steers. It doesn't matter whether the cattle or Tim Foote are a trespasser, licensee, or invitee. The claim doesn't depend on that. And yet one of the many errors in the submission of this charge was it made everything contingent on the finding of lessee status, which is just simply incorrect. Now, as we go over into the licensee, invitee, trespasser, question number 1, in preparing for oral arguments, I came to what I think for this case is a very profound conclusion. And that is, people are not steers and steers aren't people. People have legal rights. Steers don't. People have legal duties. Steers don't. And so through the submission of this charge, I think there's been a confusion about in determining the status of the steers and applying that to the law. For example, when we're looking at the status or the relationships of the parties on the premises, are we looking at the status of Tim Foote, or are we looking at the status of his steers? His steers don't have a duty. They don't have a right. Tim Foote, as an invitee on the property for his benefit, he does have legal rights. Tim Foote is benefited by those steers being on there, as were the possessors of the property, Mackie Yates, the lessee, and Stiles, the owner. So clearly the steers were there for the mutual benefit of Tim Foote, the lessee, Mackie Yates, and Stiles. So when we're looking at people, clearly Tim Foote and his property are invitees. But what the submission of the error, or the error in the submission of question number 1, was to treat steers as people, steers as them having a status. And I think this is basically was done with an inaccurate application of the Warren versus Martin case. That, in Warren versus Martin holds, in absence of some other duty, the operator doesn't have the obligation to fence out cattle as long as there's no other duty upon him, and as long as his use of the surface is that which is reasonably necessary to carry out the dominant estate purpose. Now, there's another, I think, important point on dominant estate versus serving an estate, and that is who actually has the right to exclude others? Who has the right to exclusive possession? The oil and gas lessee only has the right to use however much of the surface is reasonably necessary to produce the minerals. That is really in the nature of an easement. Just like if you have an easement for ingress and egress across your neighbor's property, you have the dominant right to use that surface for those purposes, but you don't have the right to exclude others from its use. And the same has to apply with an oil and gas lease. The lessee indeed has the right to use however much of the surface is reasonably necessary to produce the minerals, but the lessee does not have the right to exclude others for other uses of the same property. They can prevent interference in the oil and gas activities, but they can't prevent others with a right of exclusive possession in the property. So this is another important point in looking at the relationship to the parties, that basically by taking arguments out of, or making arguments from Warren versus Martin, the defendants are claiming they had the exclusive right to possession of that area and nobody else could enter it for any purpose or any reason and anybody or anything that came into it constituted a trespasser, and yet their right to possession was limited to their use. It wasn't exclusive. Whereas, subject to the dominant estate of the oil and gas lease, Mackie Yates did have the right to full possession. Mackie Yates did have the right to exclude others. Mackie Yates is the one that had those rights. So the relationship needs to be looked at is the relationship of the person with exclusive possession, in this case, Mackie Yates as the lessee from Stiles, and Tim Foote, who for the promise to pay money acquired the right to use that surface. Now, another important point on the submission of question number 1 is it was error to submit it. Now, the lawyers disagreed on whether the Steers and whether Tim Foote were trespassers, licensees, or invitees. But the disagreement is not on disputed facts. The disagreement is on the proper application of the law to the undisputed facts. So in this instance, the actual question is a legal question. There's not any dispute about why Tim Foote was there or what the financial arrangements were. There's not any dispute about Mackie Yates' right to exclusive possession. There's not any dispute about what Texcel was doing on the property and what they had done in the past and the activities they had assumed. The only dispute was on the application of the law to those undisputed facts. So therefore, it's a question of law. So they're erroneous as a matter of law to have submitted that to the jury for determination. And
Mr. Lovell, just one
Yeah.
quick question.
yes,
Could you give us, I know that the size, the entire wheat pasture was something, I think it said it was about a section. How much of the area, just a ballpark approximately, was surrounded with the electric fence?
I would estimate 1 acre. I don't know that anybody measured it, but it would be
Sure.
in the nature of 1 or 1.5 acres.
Okay, thank you.
So since the status of both Tim Foote and his steers on the property really depends on the analysis of the proper relationship between whom. It has to be between a person, Tim Foote, who had his property, the cattle there, and the person with the right to exclusive possession, which was the farmer, Mackie Yates. That is where the relationship needs to be determined. And in doing that, it's clear when you read the PJC and when you read case law that Tim Foote was an invitee on the property. He just simply was an invitee. And the fact that his cattle were on the property as an invitee, which meant those that were in possession of the property had a duty to warn. And
So Mr. Lovell, it's your position that Mr. Foote was an invitee to this 1 acre that's fenced off with an electric fence?
he's an invitee to the entire premises that included that.
Okay.
And another important factual point there is that when this spill occurred, much of the oil and salt water went outside of that 1 acre area and out into the wheat field. And many of the cattle were actually in the oil and salt water out in the plowed wheat field. Well, the plowed ground on which wheat was growing. They were actually out in there in the oil and drinking the oil and salt water. So, of course, we can't identify exactly which steers drank it within or without the enclosure, but certainly the evidence is clear that some of them were outside the enclosure and they were getting into the oil there. The another point.
Sir, I have a quick question. Is it your position that because invitee status was conferred upon Mr. Foote, that the same status would be conferred upon the cattle?
Yes.
Okay.
Yes, they would have to be. Otherwise, you're treating cattle as people, and you're placing legal duties upon them, and you're granting them legal rights, and you're, I say you, the law then is trying to apply the rules for under 324A of the restatement and licensee or invitee status or trespasser status. When you read the law in the cases in the restatement, they all address people. They address people with rights and legal duties, and it's simply inapplicable. It just doesn't fit when you start trying to do that with cattle or other animals. Another point of error, of course, is the judge's refusal to submit any question in regard to Tommy Decker. He was the primary tortfeasor. Clearly, he was an agent of Texcel, an independent contractor, but the agent of Texcel on the property. He was the one that testified he saw the cattle get through the fence every day. He's the one that didn't. At one point, he said he told nobody except staff. At other points, he claimed to have told some other people. That's a disputed fact. But what is not disputed is he clearly was the one charged with responsibility for maintenance. He clearly is the one that was aware there was a consistent problem with those cattle getting through the fence. And he was clearly aware that he was the one doing it. And yet he didn't warn beyond the first time. We don't have any clear evidence that he warned anybody, which allowed the cattle to get in there that one last time on April 4th, break the PVC plumbing, and which caused the death of more than 100 cattle. Case law is clear. There's abundant case law that under a tort claim, a tortfeasor is liable, even if he's within the course and scope of his agency. He is jointly liable along with the principal. And for whatever reason, the judge just decided that he didn't want to have Tommy Decker have a question submitted, and we're entitled to. There was evidence of his negligence. He was pleaded. We pleaded negligence. We put on the necessary evidence and pleadings, and yet the judge simply refused to submit the question, allowing him essentially a unilateral dismissal.
Excuse me. So the reason why the judge did not allow the question as to Mr. Decker, was it?
Yes.
Is because the court did not perceive that there was a duty. There was a disagreement on whether a duty existed, and without a duty, there cannot be a tort, right? If there is a tort committed, then an individual separate and apart from the company that he represents can be individually responsible. But the issue here is, was there a duty in the first place? Correct?
I would agree with that assessment. I would agree. And of course, then that takes us back to the 3 Eastland Court of Appeals opinions that hold that indeed owners of livestock can sue those who negligently cause death or destruction or damage to their livestock, even if it is on an oil and gas lease. I will, if there's no further questions, I will give back 2 minutes and 48 seconds.
Well, I do have another question.
Okay, sure.
You say that the cattle owner is the invitee, correct?
Correct.
And these are chattels of the cattle owner, correct?
Correct.
Does the cattle owner have a duty to manage the cattle and ensure that they don't create a problem to the operator's equipment?
That might be the case. And
Okay.
I will note that there was a contributory negligence question submitted.
Okay. The invitee can't come in and break PVC pipe, right?
Correct.
Okay. And so if a chattel of the invitee comes and does that, that might be a responsibility of the cattle owner, correct?
It could be, except in this circumstance, it was exquisitely clear that that duty to fence out had been undertaken by the oil and gas lessee for 20 years. And they, in fact, insisted on having that exclusive duty.
Okay.
That's the distinction in this case.
And you pointed out some sites in the record in which you believe that there is testimony that creates a fact question on the purpose of the fencing in the first place, whether the fencing was to protect the property of the operator or whether it was to protect the cattle of the surface owner, correct?
Correct.
Okay.
Yeah. Well, what I specifically pointed out is some instances where it was clear that it was done to protect the cattle.
Right.
There are other citations about protecting equipment that I didn't recite here this morning.
Right. But you're saying there's a fact question on that issue.
Yes.
Okay.
All right, Mr. Lovell, thank you very much for your argument.
Bet.
All right, Ms. Oscarson, are you ready to proceed?
I am, Your Honor. May it please the court, counsel. My name is Blair Saylor Oscarson, and I'm here on behalf of Texcel Exploration. When Texcel learned that cattle were coming on to the surface where it had an oil lease, it had an electrician come out to repair its electric fence because it had been a couple of years since cattle had been on that pasture, and it wanted to make sure that the cattle didn't damage its equipment. These other sites that Mr. Lovell has referenced that may indicate that Texcel put up that fence for cattle just doesn't comport with the fact that's undisputed that the fence had been allowed to fall into disrepair while there were no livestock on the property. But prior to livestock coming out onto the pasture, that fence was repaired and put back in good working order. When the cattle got there, they went through the fence a couple of times. They knocked it down, and Mr. Decker picked it back up, made sure it was plugged in, shooed out any cattle that had gotten in that area, and went on down the road. Unfortunately, on April 4th, the cattle broke through the fence, damaged the equipment, caused a saltwater and oil leak, drank some of that oil, and some of those cattle died. The appellants bring up several issues, and so first I'll address their claim that the trial court erred in failing to submit a negligent undertaking instruction. Negligent undertaking theory is based on the rule that one who voluntarily undertakes an affirmative course of action for the benefit of another has a duty to exercise reasonable care in the when discharging that duty. That's the Colonial Savings case. It's a Supreme Court case from 1976. In Torrington Company, the Supreme Court took that up again in 2000 and similarly said that while Texas does not impose a duty to become a good Samaritan, the court recognizes that there is a duty to use reasonable care when a person undertakes to provide services to another. So both of those cases make very clear that negligent undertaking theory only comes in when and if Texcel would have put up that fence for the benefit of the cattle. I disagree with Mr. Lovell's characterization of Mr. Decker's testimony regarding the need for a fence. I think that Mr. Decker testified that he didn't believe that cattle could damage the metal parts, but that he conceded cattle could damage PVC pipe because that's just plastic. But that's immaterial because Texcel did repair the fence when the cattle were coming out. They did have Mr. Decker put that fence back up when the cattle knocked it over those times before they busted up that equipment. Even Mr. Cypert acknowledged at trial that the fence was there to protect Texcel's equipment, not to protect his cows. The mineral lease didn't require fencing, but Texcel chose to fence its equipment when there were cattle out there because they knew those cattle might damage that equipment, and in fact, they did. The appellants cite the Null versus Plunkett case in their brief. which they say stands for the proposition that both premises liability and negligent undertaking should have been submitted. Putting aside the fact for a second that that's a summary judgment case and doesn't talk about jury charges at all, that case does set forth the elements necessary to get a negligent undertaking instruction. And the appellants would have had to have some evidence pursuant to that first element that Texcel undertook to perform services that it knew or should have known were necessary for the plaintiff's protection. So we just keep coming back around to that. That fence was put there for Texcel's benefit, not for the benefit of those cattle.
Counsel, was there a contract involved? Is there a lease? Is there any provision in the lease that requires a fence or some type of protection?
There is a written lease, Your Honor, and it does not provide that Texcel has to put up a fence.
Okay. Could part of the reason why Texcel puts up the fence is not only to protect the equipment, but to protect themselves from claims from the landowner of injury to the cattle?
Possibly, yes. And still that would be Texcel protecting itself.
Correct.
That null case also sets out the third element for a negligent undertaking cause of action or instruction rather. And that is that the defendant's performance increased the plaintiff's risk of harm. There's no evidence whatsoever that a single wire electric fence increased the plaintiff's risk than no fence at all. And as we'll get to in a second, Texcel didn't have a duty to fence at all. Plaintiffs have claimed that that fence was not properly maintained, that the fence was somehow shoddy, but the evidence was clear that the fence was refurbished and in working order before those cattle came out, and but for those cattle busting through it, it was working fine. So despite the fact that Texcel put up a fence designed to keep out these cattle, the appellants claim that they are invitees. Now they claim that Tim Foote was the invitee of Yates and or Stiles, but that's really not the point here. The point is what the duty of Texcel owed to Foote and those cows, not what duty the subleasor and the landowner owed. It's the duty that Texcel owed. And
do you agree with appellant's position that because Mr. Foote is characterized as an invitee, that the same status would be conferred upon the cattle?
That was not raised at trial, and so I think that was waived in regard to the submission on that. But I don't guess I make I guess I don't see that distinction as being as important as Mr. Lovell does. Since 1954, the Texas Supreme Court has said that a mineral lease holder, that the only duty that a mineral lease holder owes to the owner of cattle is not to intentionally, willfully, or wantonly injure the cattle. And so I think that the court said in Warren Petroleum that the duty is owed to the owner of cattle, not to the cattle themselves, because I think Mr. Lovell's right that we don't owe duty to property. But be that as it may, it's the same idea. The court said in that Warren Petroleum case that the mineral lease holder is under no duty to fence. And they specifically said, and this is important, that the mineral lessee is not liable to the cattle owner when the cattle are poisoned by drinking refuse near oil wells operated by the lessee. So when the court said that the only duty is not to willfully, wantonly, and intentionally injure the cattle, that means as a matter of law that the cattle owner cannot be an invitee of the mineral lessee, because the duty owed to an invitee is more than that. So that only leaves us two categories: licensee and trespasser. And that's why the court's question number one, coupled with its definition of licensee, was proper, because the duty owed to a licensee and a trespasser are to not willfully, wantonly, and injure the cattle. The difference being that for a licensee, there's an additional duty to warn or make safe conditions about which the licensor knows or should know. So the jury was to determine, based on this definition of licensee, which the court properly defined as being on the premises of another with the express or implied permission of the possessor, but without an express or implied invitation, were those cattle on Texcel's property with express or implied permission. And that's why question 1, which was on the occasion in question, were the plaintiff's cattle licensees on that part of Texcel Exploration's premises under consideration. So the jury was charged with determining were the cattle on Texcel's property with permission. And the jury properly answered no. The evidence was undisputed that the cattle busted through a fence to get to Texcel's equipment. And so that ended the inquiry. There was no reason to go further in the charge. Now, Mr. Lovell points out that the oil got outside that fenced area, but it's important to note that it didn't get outside that fenced area until the cattle broke into the fenced area and tore up the equipment. The cattle caused their own injury.
What was the equipment? Was it part of a tank battery? Is there around the tank batteries? Usually there is a containment fence. What about that?
So much of it came out, and you're correct. It was the containment tank for the saltwater disposal system. And so much of it came out that it overflowed. And the testimony was also that it went under the barrier system. Appellants even cite General Crude Oil Company versus Aiken, which holds that Texcel's only duty was to refrain from injuring the animals intentionally, which the evidence is clear that they did. I've gone over my 10 minutes, so I'm going to pass it to Mr. Rutherford.
May it please the court, Brian Rutherford for appellee Tommy Decker. I'm going to jump into the issue 4 with respect to Mr. Decker, and if I have time, I may cover some of the issues that the judges y'all asked as we went along the way. The primary issue 4 against my client, Mr. Decker, was that he should have been submitted with respect to independent liability. I would argue at this stage we don't even need to get there. That because of the jury's answer to question number 1. We don't get to question 2 at all. So for this court to issue an opinion affirming what the trial court did with respect to question 1, we don't even get to this secondary issue. Nevertheless, were this court to say that the trial court did something wrong with respect to question 1, and we're moving on to liability questions and Mr. Decker and so forth. At the time, we moved for directed verdict. The judge said he had some concern about there being enough evidence to submit Mr. Decker. He didn't think it was as clear as Mr. Lovell thought it was at the time. He denied the directed verdict. Over the next, of course, several hours, we had an informal charge conference. We went back and forth. We discussed a great many issues. And I think it became clear to the trial court at that point, as we were discussing these licensee trespasser issues, that we had to address that predicate question first before we even move on to liability of individuals. So when we got to the formal charge conference from Reporters Record 5, it's page 160 and on, when we're discussing that, at that point, the trial court, in looking at the jury issues and crafting the court's charge, he came to the conclusion that what remained against Mr. Decker, there was, as you pointed out, Justice Williams, no legal duty. My client did not engage in independent activity out on that pasture, in the enclosed area, anywhere out there, except with respect to his employment by Texcel. And, you know, we can all think of any number of things that may change something like that. You know, I've stopped many a time and helped somebody on the side of the road. And when I get out to help somebody and change a tire for them, do whatever I need to do, that's when you got to pause, right? You got to say, I am undertaking a duty. I'm doing it as a good Samaritan and I'm helping somebody out. But wait a minute, their kids shouldn't be running around on the side of the highway. We need to get them in a safe place. For example, if Mr. Decker were out there hunting, he would owe an independent duty outside of what he was doing out there for Texcel, not to shoot one of these cattle, you know. So there are possibilities of an independent duty, but in this appellate record, there is no independent duty with respect to Decker. The only reason he was out there was to keep this pumping equipment working, to make sure it was in good repair. And if he saw it, to address and let Cypert and Foote and the others know, hey, your cattle are knocking the fence down. So
Was there a claim in the lawsuit at the time that it got to trial about the adequacy of the containment fence? Because he's a pumper, and I assume that would be his duty.
So I would not call it a containment fence so much as an exclusion fence, right? We want to protect
Right.
our
Let
equipment.
me make myself clear. I'm talking
Yes,
about the containment wall that holds liquid. Was there a claim about that, about the containment area, the whatever you were using to contain it? Usually it's dirt and may have some plastic.
An earthen dike or something like that. I'm
Right.
not aware of a pled claim with
Okay.
respect to that,
Okay.
Your Honor. And to Mr. Lovell's point about, we can't tell, what cattle may have been injured inside or outside the fence. Ms. Oscarson is absolutely correct when she states that the cattle caused their own injury in that regard. So I would say that that is not an issue that was raised with respect to submission of the jury charge and so forth.
Okay.
So circling back around, I would argue again that there is no evidence in this appellate record with respect to an independent duty owed by Mr. Decker out there on this property. And so the trial court correctly did not include him in the jury issue on that. And additionally, there's no harm. Mr. Lovell was able to argue during closing argument that Decker is Texcel, Texcel is STAP, STAP is Decker. It's all interwoven. So if you find liability that one of these people or entities did something wrong, then you put it on Texcel. And I think that's the correct result under the law. Of course, the jury didn't get there, but that, nevertheless, it was correctly submitted. So there were a couple of questions about cattle status. We looked at in preparing for this and the lengthy off the record discussions with the trial court. We went through the Encore electric delivery case versus Murillo, 449 Southwest 3rd, 583. That was one of the primary cases we looked at on factual predicates. Because
Give me that site again, please.
Yes, Your Honor. It is 449 Southwest 3rd, 583.
Thank you.
Yes, sir. That's the principal case we relied on. And, Mr. Lovell, one of the arguments he made is it's a question of law. Status is a question of law. Well, it's a question of law made with reference to the facts. And if there is a fundamental disagreement about what the facts are, then we submit it to the jury. And the Pattern Jury Charge Committee acknowledges that. And this isn't one of those weird situations where I was out there creating some factual predicate question. I pulled it from PJC 66.6, premises liability, plaintiff status in dispute. So it is wholesale pulled from an existing body of law. So I would argue it was proper submission for that purpose. We haven't really touched on the other issues. The jury misconduct issue, I think, is a non-issue. There certainly has to be an affidavit. There could have been an affidavit from Mr. Cypert if that were the case. With respect to one of the claims was the submission of apportionment and liability. Again, because there is no issue with respect to my client, I would argue that it was properly submitted. And at the end of the day, this is one of those situations where we look at what the trial court did. And I think the judge was very well tuned up on the factual issues. He had heard testimony from the plaintiffs. He had heard testimony from Texcel, STAP, Mr. Decker, and others throughout the course of a couple of 3 days. And he knew very well what these issues were. So when he was looking at how do we craft the charge and how do we broad form submit it, he knew what he was doing, and it's not an abuse of discretion. The trial court acted with respect to guiding principles of law, which is the standard of review for this court. And we looked at Murillo, we looked at the Warren Petroleum case that's cited in the briefs, and the trial court made the correct decision that We got to decide what the status is of these cattle, because they're the ones who cause the injury or cause the breakage. They're the ones who cause the injury. And then, of course, the next question, if we get there, is did the negligence of any of those approximately cause the occurrence in question? And we've got, as Mr. Lovell said, we've got the contributory negligence of the plaintiffs, because they don't have clean hands. Their record is replete with testimony that they knew on several occasions that the cattle had gotten in, and they chose not to do anything about it. They didn't protect their own cattle. And the jury's able to look at that, and had they gotten there, I think they would have gone. They definitely would have put some liability on the plaintiffs. The remaining issues don't really address my client, but I'm happy to address any other questions or concerns the court may have at this point.
I don't believe we have any other issues.
Thank you, Chief. Then I'll tender
Thank
my
you.
time back, and I appreciate the opportunity.
Ms. Oscarson, you've got 40 seconds if you want to use it.
I think I'll give that time back, Your Honor.
Thank you very much. Mr. Lovell, we'll go, when the clock resets, we'll call on you for a 5-minute rebuttal. You may proceed. Mr. Lovell, you're on mute.
Thank you. I got ahead of myself. First, I think it's important for the court to look carefully at the citations in the record to what the plaintiffs did or did not know about the cattle getting through the fence. I think that there's been an overstatement made about the knowledge of Foote and Cypert. Foote had virtually no knowledge of that. Cypert had very little. I mean, that's what the record actually shows. Whereas Tommy Decker testified, he saw it daily. He ran the cattle out daily. And he claims that he told a mysterious cowboy about it once, which we can't identify who the cowboy was that was told. Frankly, we don't believe
The
that.
testimony on that issue is disputed?
Yes. Oh, yes. Yes. And the next point is, I think it's very important for the court to look at the Weaver versus Reed opinion out of the Eastland Court of Appeals, your court, because it very carefully limits the application of Warren Petroleum versus Martin. It explains that Warren Petroleum versus Martin was a case where there was no evidence and no claim of negligence. And it was a situation where the condition or the event that caused the poisoning of the cattle was determined by the court to be ordinary operating procedures, so that the oil operator in that case was doing and using land as was reasonably necessary to drill and produce the minerals. And that's one of the clear distinctions that the Weaver versus Reed case makes, because in that case, there was cattle that were poisoned by a lubricant. Some of the lubricant was put on the end of some pipe threads so the pipe threads wouldn't rust. Some of it was in an open container that was left out by an oil field employee. And what the Eastland court found was, well, leaving lubricant on pipe threads, that's ordinary operating, that's within the scope of what they're supposed to do to produce the minerals. However, leaving open containers of lubricant around, that's not. So there could be negligent liability for leaving the open container of lubricant, but not any liability for painting the pipe threads with it. So that case very clearly shows the distinction between what's reasonably necessary operations and what's not, which limits the application of the Warren Petroleum case.
So, Mr. Lovell, I think the court, I can see that the court is struggling with duty, and that's why they submit an issue on whether we have a licensee, because the court is unsure about duty, whether there's a duty on the part of the oil company. And so what do you believe we should be looking at? What case should we look at to say, in this instance, the oil company had a duty?
Texaco Inc. versus Spires, 435 Southwest 2nd, 550. Curry versus Ingram, 397, Southwest Second, 484. And Weaver versus Reed, 303 Southwest Second, 808. If there are no other questions, I'll turn back my minute and 14 seconds.
Thank you very much. This is a note for everybody in the case. If you cited some cases today that aren't in your briefs, if you want to, we'd certainly welcome just a letter that says, this is a case I cited today that's not in my brief, and just give us a cite. That way, that might help us in case we wrote the name down wrong or a cite down wrong or something like that. Doesn't have to be any formal thing, anything like that. But with that, your case is submitted. I'll now turn it back over to Ms. Williamson, and she will recess us from this case.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.